Okay, our next two presenters, Marissa Snyder is going to be one. I already introduced her. Our other presenter is Paul Charles, our newest deputy DA. Most of you probably met him. He's a native Californian. He went to college at Laverne College, which I'm not quite clear on, but huh? Okay, yeah, no, I had that part right. He went to Willamette Law School. He passed the bar last year, and he's came by way of Lake County. It was kind of interesting. He went to work over there as the first, probably the first deputy DA ever over there on a grant, which is kind of a bubble that you're riding along. Well, he had a new boss. The DA had been recently elected over there, and she immediately got into it with the one and only judge in town, started affidaviting the judge, so they started a recall campaign against his boss, and she resigned not very long after he took up residence over there. So he was in an office that is pretty busy over there. There's a lot of drug trafficking. 395.
140.
Oh, one.
And 395.
And yeah. So anyhow, Paul was over there doing all kinds of things that brand new deputy DAs don't do, which is going out on death calls, helping kick down doors, and all kinds of things like that. So he has a lot of experience for a new guy, and we're real happy to have him here. So, Paul,
All right, so because we're the two newest deputies, we get stuck with a lot of the new trials, which are DUIs. So we both experienced DUI trials. Paul had his first one, and it was a lot of fun. Old DUIs are lots of fun. So we're going to be talking about DUI trials and DUI investigations, in addition to some Miranda and trial prep that can be helpful to you guys and us. So there's some new case law. A lot of you guys have already utilized Banks, and we appreciate it. Banks is the real problematic new one, which is our very favorite lovely case, which we'll explain in a second. The other cases are more changes in some stuff. Swan and Taylor are the cases that say Miranda violations right before breath test throws out a breath test. So those are those kind of problematic ones. So be wary of Miranda, which is something we're going to talk a lot about. And Paul has some admonitions for you guys on that one. And then a lot of the other stuff came about talking about what is reasonable suspicion versus not reasonable suspicion. So I just want to list those cases for you, but Banks is the really important one. So what I want you to do with Banks, and I think a lot of you have done this, is think roars. It's a lot like roars. You're going to give an admonishment, much like you do with roars, if they're not going to take the breath test. It's also kind of helpful to mention it anyway. Mention the fact that you want their physical cooperation. Even if they're consenting, talk about that, because that's the stuff that's really big right now. That's the stuff that's kind of changing. Breath tests are kind of, the Court of Appeals is playing around with breath tests a lot more. So making sure that you're being as clear with defendants as possible is going to be a key part of this. So I know that the jail has the Banks admonition. I think that Seaside does too. I think I've seen in Seaside cases. If you don't know what I'm talking about, you should, especially if you're a road cop. So please make sure you know what that is. But essentially it's just much like Roar's saying, all we're asking for is your physical cooperation. It's almost identical to Roar's, other than the fact that one's for FSTs and one's for breath tests. So one of the biggest thing with DUII investigations, and it was talked about a little bit in the search and seizure that Scott did, this is just kind of building on it, and some of the stuff that, especially in those cases where you're not the observer. So a lot of you are developing PC and reasonable suspicion based on driving that you observe. That, I think, is probably 80% of your cases, I would guess. Correct me if I'm wrong. But there are those cases where you're called to the scene and you're not the one observing the driving. So specifically, we talked a little bit about the touching the hood of the car. That's a search. But if you ask, hey, can I just touch I need your consent, feel free to ask that question. It's
We have one thing on this. The one thing, I had a DUI case down in Lake County where the officer didn't see the driving and somebody else did. If you can get as much detail from that person as possible, like not only did they see him, but what were they doing with him, how close they were, what did they smell, any observations that person described, walking, talking, slurred speech, anything like that would be helpful, because it's probably going to go to a suppression hearing,
And
it really helps.
that largely goes to that call any complainants. So you can do this afterwards, but it's really great to have ahead of time if you have the ability to. So if you have 2 cops there and one of them can just call the complainant, that's helpful. But getting as much about the observations that they had is super helpful. A lot of things that happen in DUII trials too on people that are at that like 0.07, 0.08, and you didn't observe their driving and you caught them like 10 minutes after a call, they're going to claim that they drank once they stopped. So pinning them down at the time, on video, on body cam, specifically telling you, this is how long I've been here, this is how much I drank before, this is how much, so that they can't make that claim later. Super helpful for everybody.
Look around the car too, for any open, discarded open containers or lack thereof, more than anything. And also you want to be looking under the seat and anywhere else they might have stashed a pint.
And so a large part of this is kind of your guys' experience. So I'm not going to try to play on your guys' experience and whatnot and how you do your investigations. But these are the things with your driving, with your ones where you're observing it, you develop PC in a much different way. Remember that if you're going to expand from a traffic violation to a DUII investigation, that you're observing those things, getting it on camera. And the biggest part with this is try to utilize your body cameras. We have them now. They get played no matter what in a DUII trial. The more you can get, even going a little closer to people or taking your body camera off and getting better video is going to make it easier for us to show those things, because although you guys can see a lot of this stuff and we're having you testify to that, it's easier if we can put it in front of a jury.
And on body cameras, because I know most of you guys have a cover officer come when you do FSTs and stuff. The other officer has a body cam and it's on. I don't think there needs to be a whole new report, but just notate it in the arresting officer's report that this person has a body cam, because we still have to turn that one over as well.
And also turn it over if you have that person. So there's times where we know for a fact that there's body cam because it is notated, but we don't get it immediately. So, or somebody will not have, they'll say my body cam died or something like that, and it won't notate that somebody else had their body cam on. So always letting us know. Controlled substance DUIs, I think everybody's a little uncomfortable with them unless you're a DRE, but they're the ones that we have go to trial a lot more often because they're a lot more triable. Just make really good notes and try to make sure that you're watching for those signs that you know are very specific. If you are going to be calling a cover agent or a cover officer and you know that there's one on duty who is more comfortable with a controlled substance and you think it's a controlled substance, do that, because these are the cases that are going to get tried. Do you have anything to add because you just experienced a controlled substance DUI?
Yeah, the DUI trial that was over the last 2 days, she had 6 drugs on board. It's like a hometown buffet of stuff. And the DRE called CNS stimulant, which she did have as a prescription of amphetamine. But I think the helpful thing in those situations is, I know in the reports, like, oh, I called, or if I suspect CNS stimulant, if you go through the matrix and be like, I suspect it because you have jittery, like all the general indicators would help a lot, and not just like the top part of the matrix. So, I mean, if we do go to trial, as you testify, it's, we can tell the jury or tell the story to the jury with those indicators, and I think that would have been helpful.
And making sure on those cases that you do think are a controlled substance, try to sell the DRE a little bit. I know they have to consent, I get that, but it is something that is extra helpful. It gives us a little bit more expert testimony about stuff. I know that it takes a lot longer. That's a large part of the reason a lot of people don't consent to the DRE evals, and I understand that, but trying to sell those are the ways that we're going to be able to prove that.
An easy way to do that is to say the DRE is there to determine whether you're under the influence or not.
Correct.
They don't care.
Yes, listen to Uber on that. Make sure that you sell it as, we think you're under the influence, but this guy knows a little bit more and can tell me that you're definitely not under the influence.
Or have medical issues.
Or have medical, yeah, exactly.
Some people try to play, if you will, that
Yes.
role, and so it's just, if you say that. I've had medical rule outs before, that doesn't mean maybe you guys did anything wrong, that person's still impaired, it just turns out that it's a medical issue.
Right.
Fine.
So yeah, utilizing DREs actually helps you as well for those cases that to you may look like something and not something else. DUIs, not just, and by DUIs with drugs, I don't mean DUIs with controlled substances on the person, but DUIs where you see something that indicates to you that it got mentioned a little bit in the stops and search and seizure PowerPoint, where you see somebody who's twitching, they have a previous PCS conviction, you know them to be a drug user. Remember that much like taking a traffic violation that you just stopped the person for into a DUI investigation, you have to have the same reasonable suspicion to move it into that investigation, to ask them, do you have drugs in the car? So make sure that you have that to develop those cases. If you see a pipe, that's definitely something that will move that into the reasonable suspicion. You can start asking questions. There's some case law that's come down recently that makes it a little more difficult to move that into the drugs, not just DUI.
Can I say something real quick? Yes. On the converse side, I've had a couple cases where I think it started off as a DUI investigation, and then drugs were found, and then there was no completion to the DUI, and I think maybe because someone thought it was a felony. I just don't know why exactly, because
Yeah, that's happened.
the DUI, the punishment.
Yeah.
Yeah, okay, I know
Yeah.
why.
So
But the DUI punishment is so much more worthwhile for our society. I mean, we get treatment, they're gonna get, eventually get a felony if they keep going, and, I don't know, I just encourage you, if there's a DUI
Yeah.
there, to do that investigation, or call someone if you don't want it.
And on that topic, that has actually happened. I think I've had 3 cases or I've seen 3 cases in our office very recently where it was somebody found drugs, and so it became drug investigation, and they were talking in court, and we're dealing with a no contest plea, and we're reading out this thing, and we're like, but there was, and then we kind of stop, and then the judge is like, oh, there wasn't an investigation. So try to investigate those. As Don said, you get a lot more out of a DUI in a lot of cases. PCSs, because they're a 1 on the guideline, even if they are a felony, you don't get much. You get a lot more in this case with that driving under the influence charge.
And we can get a plea on a DUI. If we have a DUI PCS case, the defense attorney's got a built-in argument to his client, I'm getting rid of the felony for you, and I'm pleading you out to the misdemeanor. So if you investigate them both and they're both there, we'll probably get the plea to the DUI, as long as there's good facts.
It's a half-person crime, too.
Yeah, exactly. DUIs are half-person crimes. So there's a lot of reasons that DUI needs to be investigated. And I think that goes to a huge point. DUIs are a pain in the ass. We get it. It is a long investigation. Even the breath test refusal and the FST refusals are going to be long no matter what. It sucks. I get it for what you guys see as a misdemeanor, but we get a lot out of it. The state gets a lot out of it. We protect a lot of people by doing it. So investigating them is necessary. So other weird issues, sometimes we get people that will actually request a blood test. They are allowed that. If you guys have all read the ICCR a billion times to people, in there it says you have the right to request a
Independent blood test.
blood test. So this is kind of the guidelines. Ron came up with this guideline, which is unless in custody, you don't have to drive them over, but you have to make sure it happens. If they're in custody, you have to make sure they get it done. If they're requesting it, it's their duty to get it done. But you want to make sure you're following it so that we have it too, because as you know, blood tests are going to be slightly different than what the breath test says because it's in more immediate from the blood.
Currently, the law only requires that you release them from custody and they get to then worry about transport. I could see our court system saying, bullshit, that it ain't gonna work because, how meaningful is it when they were left out on the streets in the middle of the night, et cetera, et cetera. So that's another potential issue.
All right, and then, so what are you guys having trouble with? I want you guys to kind of bring up some of the issues because I know that there are many DUIs. Yes, Hoover.
Well, we just ran into a study talking about the difference between alcohol and a prescription CNS depressant. I don't know how many DRE evals we have where it's a CNS depressant, but they've also had a couple beers. So you smell alcohol, but you're seeing a ton of impairment. Yet she's saying all we can ask for is
Well, I think what she was trying to say, if I'm interpreting Judge McIntosh, and God knows if I can, but is that you need to delineate as best as possible those things, because although they're both CNS depressants, as you guys have testified, they have somewhat different indicators. Alcohol is its own weird special CNS depressant, and so you delineate those other things you may have seen. No?
Well, ETOH can raise your heart rate. That would be one thing, but that's just
Right.
typically later in
That's hands-on.
Well, so
process. So really, there's not a whole lot that's going to be different there, except for the odor.
Now, if they're saying, I drank a couple beers and I took Xanax, that's no brainer, you can have both, but.
yeah, I think you're gonna.
Truth about what's going on, so it's gonna be tough for us to.
I think if you are.
A lot more impaired than
That's what-
together.
No, but I think if you already have the breath sample and you use that as part of the probable cause, I think you're okay. I think what she was saying, if you don't have that breath,
To be fair on that, so we asked for that breath sample. So we write the search warrant, breath and or blood. We can't force breath, we know that.
yes.
So they said, I told you I'm not giving you breath, I'm not giving you breath. Okay, well, it's time to get some blood. Well, then what do we do from there? Because we're not gonna know whether it was, and I'm not saying, so those of us who are more trained and know what to look for, I can see maybe being able to take one of those things and do the weeds on this. But for some officers, they may not. They may see this as, well, I'm just gonna get blood and move on about my business. And then we get a blood sample back in their notes too, of 3.
So I actually had this come up on one case, and APD's not here to talk about it. So I had a case where it came back from the lab, and the search warrant, I'm vaguely sure, I'm pretty sure the search warrant said for intoxicants. It didn't say specifically for alcohol, and it came back, and then they sent it out to Washington to get tested for drugs too. So although we don't have a blood that tests, or don't have a lab that tests blood for drugs, we do have another lab that we can send it to if it comes back that way. So as long as we have blood left, and that's why we take 2 vials, and as long as the chain of custody is continued and you have the authority through your department to do it, sending it up to Washington after you get that .03, I think is okay.
I just worry that some people they're seeing a lot of impairment with alcohol. They have the person do a breath test, they blow it 03, and they go, peace out.
And that, I will say, that is something that has been happening, is we're getting ones where it's either a 0.5 or 0.05 or 0.06, and they're saying, that's it. I'm not going to call a DRE. I'm not going to, on those ones, please call a DRE at least, just so that you have somebody who can say it was just alcohol or not. Because I have cases that I can't file a 0.05 with that when even they're saying this is the level of impairment I'm seeing. I mean, I can, it's just really hard to prove.
You also seem like a lot of McIntosh speak like more simple itself rather than that. So she's basically just saying if you're asking for something, you need to have facts to support it.
So if I'm looking for alcohol, that's great, that's easy, I smell alcohol.
Yeah.
If there's other stuff on board that I might be saying, they may not be telling me the truth, I can't, she's saying, well, if you want the other stuff, you gotta add in there, they're taking Xanax.
Well, no, I think if you say, I don't smell a significant odor of alcohol, but I have somebody who's acting like they have a CNS depressant on board, which may or may not be alcohol, I think if you can delineate the facts, and I think it's just going to be about being very specific with her. I think that's what we've all the people that have put search warrants in front of her and have come back out and talked to us, she wants specificity as much as possible.
Yeah, you can't have too many facts, and I think if you just say that some physical characteristics are indicative of both alcohol and a CNS depressant, you ought to be able to write for both. So, I think it's a
Yeah,
question
Training
of
comes in too.
Yeah,
Because
exactly.
your training experience, so we'd be able to tie those 2 facts together.
I mean, with you, Hoover, you're a previous DRE, you have a ton of experience with controlled, so you delineate that and you say, it does not seem to me that this is just alcohol, there's something else going on. Right, and that's the thing that we need to hone in on with this DUI presentation is, yes, DUIs suck. Nobody wants to do a DUI investigation. They are long, they just aren't fun. But
and juries let guilty people go.
Correct.
So-
And I know that's disheartening, but the more we get this county dealing with the controlled substance ones, the more we see the marijuana ones, it's going to develop more understanding of that, and we're going to get better at it, and we're going to get more convictions. We're not going to have situations. Yes.
So I think the fix for the one is, if someone does comply, and they do give you a breath sample, and they are O3, and they're still torquing the floor up, then it's time to ask for that search warrant.
Yes.
But I've also had the exact same thing that Sergeant Gregory, and I believe Officer Wood had the same thing, is you're applying for that search warrant. You know the person's impaired, everything you're seeing is a CNS depressant, and you don't know whether it's the alcohol and or CNS depressant drug, and that's what becomes.
Well,
We have-
on those ones where you have a refusal, yeah, if you have a refusal, you say it's a CNS depressant, and you say it can be either alcohol or a controlled substance. That's what you worded on in the search warrant, because you don't know.
You got to be able to come down and say it is probable that there is this controlled substance in their system because alcohol alone wouldn't cause this much impairment.
Or alcohol, it is probable that alcohol and or another CNS depressant is in the defendant's system.
But you got to have the word probable in
Yeah.
there, as she pointed
Yeah,
out.
just utilize the word probable a lot. All right.
Yeah. It'll remind you.
It's probable that. Any other weird issues other than those that have come up? All right. So these are our do's and don'ts in investigations. Body cam, because we have them and they're utilized a ton in DUI cases, utilize them as best as you can. Chamberlain asked me to point out, especially with cases where you think it's a controlled substance, kind of get a little closer to their eye. I know it's awkward to do this, but if you have the ability to take your body cam off, try to get a video. I know it's hard for the troopers who only have dash cam. Yes.
I have noticed too, speaking with that, I've been seeing officers do their DUI investigation, and they're used to their body cam, they're even positioning themselves right, but like you said earlier, if you have a second, try to get that another angle, and also utilize your dash cam. It's doing a lot of people out there.
Use your body cam as your schedule to see if that works.
I'm going to go with no on that, but that would be cool though. And specifically with the troopers in here, I had one, sorry, Morgan calling out, that we had a previous DUI where he did all the FSTs, but he did them away from the dash cam. So we didn't have the visual of it. It's fine. It was one of those weird DUI. It was a weird case and we lost and it was my fault. It's okay. Not the point. But it was another really old DUI that kind of had languished. But for those troopers that only have the dash cam as their camera, make sure you're utilizing the space in front of your car. So move your car if you have to, because you guys don't have the body cam, you only have the audio cam, and so utilize it. So you're not going to be able to get the close-up details, but try to utilize it so you can see the trembling or the wobbliness, all of that.
We're also trying out at the county 360 body cams right now.
Oh, yeah.
You can literally, as you're watching the video, grab the screen and scroll, and it will do a 360.
Yes. Cool stuff. So body cams are helpful. They're also really hurtful if you don't get them done the way they need to be done. So use your body cams and be helpful.
And don't say anything you don't want your mama to hear.
Exactly. Be careful with body cams. This goes to any situation. Know that it's on for yourself too. When you're reminding the defendant, remember you're also reminding yourself, I have a body cam on. And make sure you tell your second that your body cam's on, just in case. It's really helpful.
Or when you're at the jail.
Or when you're recording the jail video, make sure that's the jail video. They're seeing everything, they're hearing everything. Talk to complainants before sending reports in. That one's going to come up again. Utilize your DREs. Just please utilize your DREs. I know they're not always available. I know that it makes things longer because you also have to stick around. But especially with controlled substances or those lower blows, utilize them. Utilize the OSP alcohol influence interview report whenever possible, but as the don't say, don't use it in violation of Miranda. That has happened. It has caused breath test refusals to be thrown out. That's what happened in, I think, Swan or Taylor, one of the two. Utilize it because you're going to get it, much like the DV report we're utilizing. You're going to get a lot more information because you're asking questions you may just forget to ask. They may be questions you already asked, but getting them documented, great. Attorney phone calls. This has come up as an issue in what I've heard about in DMV hearings and other things. You have to give them privacy and you have to give them meaningful time. It's always best to just ask them if they want to have a phone
It's
call.
not just attorneys, they can call anybody.
Exactly. Ask them if they want to have a phone call. It saves you the heartache of somebody saying that they asked and you somehow missed it. Just ask. But also with the meaningful time, it's meaningful time, but if it's going to condense your ability to get a breast sample once it becomes truly exigent, so probably 30 minutes or more, you're going to say cut it off. And what Judge McIntosh was talking about with telephonic search warrants, you must record them, otherwise they're not valid, and you must provide that recording to her. So remember that. I think she brought that up, so I'm not going to talk too much about that.
And it's the burden's on us, not the court.
Correct.
I do have one more thing about the to-dos. With FSTs, when you give the instructions, if you can articulate that you're giving the instructions in the manner consistent with training, so it's all the same. Because I've seen some DUIs in other counties. I know Clatsop has a very unique way of doing things sometimes at the courthouse. But if you can articulate it so we can use them at trial, because I know sometimes that if you give them not consistent with the training,
Well, case law says as long as the OARC, as long as, it's only HDN that can get thrown out for being not. So with HDN, and I know a lot of people are uncomfortable with this, and a lot of people, there's been a few officers I've had where during FSTs, they will skip HDN completely, which part of me says is okay, because if you're so uncomfortable with it, you're going to do it wrong. It's going to get thrown out anyway. But try to train yourself, train your officers, work with each other to make sure you're doing HDN correctly, because it is important. It's a huge indicator of very specific types of drugs. If you are suspicious that somebody has controlled substances on board too, do lack of convergence if you know how to do it correctly. Because if you're not doing it correctly, then it's not going to help anybody.
And just a note, if you're drunk and want to try it on yourself in the mirror, it doesn't work.
If you can't tell, Dawn's tried. As we talked about a little bit with stops and searches, do not block a vehicle unless it's, if it's a scenario in which somebody's tried to run, that's a different. But if you're coming from a complaint on the radio and you find the vehicle, make sure your car is parked either in a parking spot next to them, or if you're a trooper and you're trying to get video, park in a spot where you can move them right next to it and have the video, but do not block them. One of the biggest problems we've been having, you guys forget to Mirandize. It's not all of you, most of you guys are good, and even the ones that are the most experienced, looking at Gregory, every once in a while, forget to do Miranda. He came to me saying, I'm sorry, so I can throw it at him. What? Yes. Yeah, so if you're already stopping them, if you are stopped and it's already a stop scenario, it's different.
Yeah.
This is mainly,
Disabled motors and that kind
yeah,
of thing.
so this is mostly, the blocking the vehicles is mostly related to those where you're getting a call and you are finding a vehicle and you haven't really stopped them yet. You're going to start with like a encounter. Yeah, exactly. But going back to Miranda, as we talked about with Swan and Taylor, you're going to cause some huge issues if you don't Mirandize. Thankfully, with Gregory's case, he didn't ask him any questions, so we were good. But you're going to cause some really huge issues if you're asking them questions right before a breath test. If you haven't Mirandized by the time that they're seated in the back seat of your car, you have a problem. By the time they are in cuffs, you should Mirandize them. You should Mirandize them you can say what you've been saying.
Kind of like Chicago voting, vote early, vote often.
Yeah, exactly. Mirandize. It really doesn't hurt. Most of the people you're talking to are drunk, so they're not going to stop talking anyway. Just Mirandize. It saves a lot of hassle. Please don't give advice to defendants. Please don't tell them that you may be diversion eligible.
Or they should call Roman.
But that's not a thing anymore. But yeah, don't give them advice. Just don't. Specifically about diversion too, because they come and they're like, well, the cop told me about diversion. And you're like, but you're not eligible. And again, back to Miranda violations. So going on to reports. So reports are something that we utilize. And they're also really helpful for you guys for cases that are 3 years old. Yes, sorry. Sure.
I just want to clarify, you say it's okay not to do the HGN test for
It is not okay not to do it, but I'd rather you not do it if you're so uncomfortable with it than do it wrong.
The tests are standardized, validated tests.
Correct.
You have to do all three. You have to do them in a standardized manner, which is HGN, the walk and turn, and everything. You get from that.
Well, so I have a suppression hearing coming up, so I actually have been researching this. And technically, the OARs state that you can do any or all of the tests. It is at the discretion of the officer. Yes, you should be doing all three of the standardized tests. Do them. Do them well, but if the scenario is that you don't feel like it's an alcohol, you're not going to do HGN. But you should, the advice here is do the standardized tests. I agree. I know that that's what you guys are taught, and do what you're taught, first and foremost. Yes. Correct.
Yeah, but we have people who haven't done one for 15 years, and they
mess it up and it gets thrown out.
What she's referring to, people who just haven't done one for ages.
And again, the
If you've
OARs,
been in detectives and you go back out on the road, you know how that goes. There's going to be things that have been updated that you aren't aware of. So lots of times detectives on the road get caught that way.
and the way the law stands is the only way a FST can get thrown out is if it is unconstitutional by definition. So it's only if it's unconstitutional. It cannot be thrown out because you did it wrong, other than HGN, because it is a scientific test.
So basically, it's up to the defense to show that you did it wrong, therefore,
But only HGN. The rest of them can't be thrown out because you did them wrong. That doesn't mean you shouldn't do them correctly and do them right. But and I'm not advising you not to do them. Do HGN because it is the best test you can do. And do the 3 standardized tests. I agree with you, Shimer. I'm not disagreeing with you. I'm just saying I would rather you do it or not do HGN and then do it wrong because it's going to get thrown out, so it's going to be a problem. You had a question, Aslan?
I was just gonna say, generally, if I'm gonna do any test, it's gonna be HGM and not the other ones for various reasons, but.
I've heard lots of cops say that, and I don't understand why, number one, and number two, it's almost impossible to convey what you're thinking the HGN shows to a jury.
Yeah.
Because you're not a doctor, you're not an optometrist. It may be your favorite test, but it's not something I think the juries pay much attention to at all, unless they've actually had it demonstrated for them. But if they're hearing about it for the first time and they're hearing about eye jerking and all that, I think I don't think they get much out of it.
So you should be doing HGN, one leg stand, and walk and turn. That should be what you're doing. If you're not doing that, there's a problem, especially if you are a constant road deputy. Those tests should be done.
If you do HGN wrong, and you say anything like, "Oh, I based my PC after
On HGN.
and then the HGN gets thrown out." That was Roman's favorite argument. Then you can get the whole case.
Yeah, so
You should do it, but just learn how to do it.
yeah, make sure you're doing it correctly. That's really the key of what I was trying to tell you was that, yeah. What? Correct, and then if you're not comfortable with HGN, talk to your supervisors and get more training. Because,
or have someone respond to see if it's good HGM.
correct, I've seen officers hand it off when they are not comfortable with it. That is fine, as long as they're part of the investigation, they're part of the investigation. But you should be doing those 3 tests. Those 3 tests are the tests that are the indicators. Those are the standardized tests for a reason. Also, the walk and turn and one leg stand are great visuals for juries. And when they're caught on body cam, also if you're either really tall or really short, please make sure your body cam is actually pointing in a way that can be seen. Because I have the ones where they're like here on the person and you got nothing.
Also, be prepared to, you get a lot of people that are physically decrepit, falling apart, that said, oh, no, I can't do that one because of my short leg or that sort of thing. So be flexible. I mean, there's other tests that you can use by counting and by, the alphabet, things like that, things that don't exploit anybody's physical problems. Also, practice your field sobriety tests. You better be able to do them in front of a jury. Because any defense attorney that doesn't ask you to but to perform the field sobriety tests in the courtroom in front of the jury is doing malpractice. And I have seen up to and including falling into the jury box by people trying to do the walk and turn test, things along that line.
And on that
So-
same topic, if you have an injury or are in some way unable to demonstrate the test for the defendant, have your cover officer do it. I actually had a DUI that came up, and that's exactly what happened, and it was helpful because that meant that the person that couldn't do this wasn't showing this, because what they would have shown was this because they couldn't move, they couldn't straighten their knee. So if you have to demonstrate a test that you are unable to do because of some sort of physical ailment, ask your cover deputy or cover officer to do it. Because for the same reason that you shouldn't show a jury that, you shouldn't be showing the defendant as a demonstration something that you can't do yourself, because then they're going to try to duplicate what you're doing. All right, moving on to reports. We need all the elements, much like what Judge McIntosh was saying, that she needs all the elements in a PC affidavit. We need all of them. And I can tell you, I know it seems silly that I'm talking about driving a vehicle, or that I am talking about highways and premises open to the public. These are things that are missing in some reports. I don't have any driving in some reports. So you need to delineate either that you observed driving, or call up the complainants and ask what they observed. That needs to be in the report. Highway and premises open to the public. Now this has come up rather recently-ish. Surf Pines is premises open to the public. I know that seems kind of anti what you think it should be because it has closed gates. It's premises open to the public. And any gated community, yes.
It's private property.
No, it's not.
Women and things are allowed on there, that's kind of.
So there's case law that
Yeah,
has,
don't buy that bullshit, Dean.
The roads that are built in there are specifically designed to access residential properties, and that's what designates it premise open.
there is case law about it as well.
By the limitation of the gate.
Yes.
Because all your public powers, all your deliveries, and all those roads are specifically designed to access residential properties, and that's what makes it a premise.
It's just like parking lots. Parking lots are premises open to the public. They're not private property. I mean, they are private property, but they are open to the public.
Anybody driving that are, even if it's gated, like they're waiting behind somebody to open the gate, you drive in.
Well, think about it this way. If UPS, which is a private agency, or FedEx, or even an average person can drive into there, it's premises open to the public. So I don't know if it's stopped any DUIs. I know it's made DUIs weird in some cases because people have perceived it as not premises open to the public. So please be wary. It's not just Surf Pines. There's other communities in this area that are kind of, I think the Reserve also has a gate. I'm not sure on that one, but any premise that is accessible to the public is premises open to the public. That's why it's worded the way it is. What?
Yeah, just, there's a definition for it. So.
And there's a definition to it. So please be aware of that. Please don't avoid DUIs because you see them inside of Surf Pines. And then under the influence of intoxicants. Yes. Yeah.
We were talking about Seaside Thousand Trails. Are you familiar with that area?
I'm not.
Right off of 12th Avenue.
Okay.
Towards the hills. And it has gates. You have to be a Thousand Trails member to go there. And it's applies to 500 sites or so. So it's very, very big.
Is it a home? Are there homes?
It's camping. It's like KOA, but it's a private sort of thing. It's like KOA, but it's a private, you have to belong. No, it seems like it's premises open to the
Yeah,
public.
it seems like it,
Yeah,
seems
same-
like it to me.
same
If,
sort of
if you can
thing.
rent a space there or
Well, you can't go in there.
what?
You have to be a member. You can't just come in and rent. You have to be a member to be.
I'm going to maintain the can FedEx and UPS go in.
But as a guest, you can go in and visit somebody that's there.
So if a non-member can go in, then it's premises open to the public.
So I was trying to say, I have friends that stay there every summer I go visit there, I would pay taxes.
Yep. So there you go. Humphrey is a member of the public. Oh, when I'm doing this. So it seems weird that we're stuck on this, but obviously there's a reason we're stuck on this because people are considering things that aren't necessarily private as private and not doing DUIs there. So if you get a call that somebody is driving drunk in that, whatever it's called, sorry,
Thousand Trails.
you can respond to that. That is premises open to the public.
That doesn't mean you just go in there and freeze.
Poaching.
But And going back to driving, I know, again, we said 80% of DUIs are probably from you guys observing driving, but on those cases where you're responding to something, we really need to know that there's driving. That needs to be in the report. And you need to, if there's somebody that's the one that's reporting it, you need to talk to them and hear what the driving was, why they called, what the reason was for not just the 911 call, follow up with them.
Just really quick, the questions are not getting.
Oh.
So if we could just
Repeat the
We need to
question.
repeat the question, sorry. All right, and then, all right, so some of the things that we need included in reports, all of your observations. So 90% of what leads us to the point of what is intoxication is your guys' observations. So the slurred speech, the watery eyes, write down anything you observe. And then, because we need to know those things. That's the stuff that's going to make us on a 0.07 or a 0.08 feel comfortable filing a charge. So make those notes in the report. On FSTs, there are standardized clues. There are the putting your foot down, there's the putting your arms. But the other things that you guys notate that can lead to your observations that lead to somebody being intoxicated, note those too, because those, although not standardized, are your guys' training experience. I've had a few reports from certain officers where there's a page and a half of the guidelines that you guys get at DPST, and then maybe a paragraph about the actual test itself that you did with the person. Basically, reports should not be 20 pages, but they shouldn't also be a page. We shouldn't be getting reports where there's a page. Then we're not getting enough information. We do not have enough to take it to trial. We do not have enough to file charges. Make sure you are including all of your observations, including those things that we need to prove DUI. So back to Miranda just for a little bit. Read it. Just read it. It needs its own slide because it is so freaking important.
But you don't actually have to read it more than once.
No. Oh, that's a good point. You only need to read it once.
Yeah, if you are talking at the scene, then you're talking in the jail, and then you're talking some other time, you don't have to keep re-advising. If you've got a waiver, you can run with it.
And, yeah.
And then I just want to say there are other cases, like just thinking of David Olson, where Detective Eason, he's a sex offender, and he said, you want to come down? And we had a big hearing about it, and he came into the office at OSP, the door was closed, but Eason explained to him why he was closing it. Gun was not shown, and Olson talked and talked and talked, and that was upheld. No Miranda. Someone might be more inclined on some cases to talk if it's not custodial, and that wasn't. So
He was told that he was going to be free to leave, and he would be leaving at any time. He got arrested the next day, I think, wasn't it, Matt? A couple days later. And I'd really kind of be surprised if that whole thing got upheld in this day and age, frankly, because the police station is just kind of one of the red flags. If you're going to interview somebody at the police station, then that's probably a custodial type of setting, unless it's in the waiting room or somewhere that's real low-key. But that Matt did a great job, and we convinced Judge Brownhill that he was never in a custodial situation when he confessed all the sex abuse.
And on the topic of Miranda's, not just in the DUI world, but in the non-DUI world as well, I've seen a lot of officers do a great job saying, I'm not arresting you yet, I just want to let you know your rights. Making it kind of nonchalant, but reading them their rights, it really can't hurt. You're going to protect yourself later. You're going to protect the evidence later if you give them their Miranda warnings.
And doubling back once more, the reason why Matt did that interview the way he did, as I recall, was because Olson was a frequent flyer, and there's certain guys that as soon as they hear the Miranda violation, it's just like, up here's copper. It's not going to happen. So Matt specifically didn't want to have to advise him of his rights because he figured it was going to clam him right up.
And again, this is based on your training experience. If you guys think that it's a good choice not to, but especially in DUI cases, you always should be. With DUI cases, we're more likely to get stuff thrown out close to like the breath test and stuff if you don't. So, but on those types of cases, I understand the DMV hearings. So
can I say one more thing about Miranda invocations? There's two kinds of Miranda invocations, either equivocal ones where you're not quite sure whether this is it. If they say, I don't want to talk to you, or I don't want to talk about that, as opposed to fuck you copper, that kind of thing, then you've got probably what's called an equivocal invocation. And it's okay to ask questions about, well, what do you mean by that when you use the word this or that? If it's just a flat invocation, you can't ask any more questions at all. And you can't prime the guy by saying, well, you know, we got these really significant charges, and then you go walking off, and then the guy comes running to you. If you've got an equivocal one, you can ask questions to clarify, but once you get an unequivocal invocation, any further questions at all are going to be suppressed.
Thank you.
What about no habla?
Oh, what about no
Then you
speaking
got an
Spanish?
uphill
Or
battle
no
to
speaking
show
English?
a knowing waiver, probably, without some sort of an interpreter.
Use
Language
Google
line-
Translate.
language line or something.
Use Google Translate. Not always the greatest thing, but as long as you can get it across. Yes.
Can I just clarify that? So
Yeah.
If you arrest somebody and then you read Miranda and right away they say, I don't want to talk to you, I want a lawyer. And then 3 minutes later you ask them the exact same question and they start talking to you and so they completely forgot.
Can't ask them
shouldn't
the
have asked that
question.
second
Can't ask
question.
them the second question.
Yeah.
Right. 'Cause
I
the
mean, if they
first-
start
the first
talking to you.
statement was not equivocal.
Yeah.
He
So-
wanted a lawyer.
Now, if they start talking to you about this stuff, no,
No.
you should not be asking any
He has
questions.
anybody time you've got an unequivocal invocation of Miranda, you have to then, the defendant has to decide to come forward, and that's why you can't prime him up. It has to be of his or her own volition.
Correct. Humphrey, you want to say something?
I was gonna ask you, the phrase, I think I might wanna talk to an attorney, is that unequivocal?
No, that's equivocal.
The Court of Appeals,
Think means maybe.
the Court of Appeals has kind of wavered on that, though, so we're not really sure.
It's okay to ask, I think that's okay to ask further questions.
I think it's okay to ask questions about whether or not they are asking for an attorney. Yeah, you can ask clarifying questions on that, but you cannot ask questions directly about. You can ask what do you mean by I think? Yeah. Or that, yeah.
What about the alcohol influence report if they want to talk to an attorney?
Nope.
No questions, yeah. So that is,
Back to that Banks case,
exact, no.
it's
goes
all a
to-
violation.
Yeah, that goes to Swan and Taylor. That kills off the breath test.
I just wanted to ask so I can go back to our secretary.
So those reports should be done as long as it's not violating Miranda. If you are going to violate Miranda by doing it, so if they have said, I want to talk to an attorney, or I don't want to talk to you, do not ask those questions.
The only thing you can ask about are what they call routine administrative questions, like your height, your weight, your social security number, things like that.
And will you take a breath test?
Yeah.
As long as you haven't violated Miranda already.
Okay, sorry.
No, you're fine. DMV hearings. So 90% of the time we hear about these, maybe, and I only have ever heard about them from Bunny. So I've never heard about them from you guys. That means that stuff has gone on. You guys have put testimony under oath, and we didn't know about it. So if you have a DMV hearing, let us know. Call our office, email us, something. Let us know that there was a DMV hearing in this case. Yes. No.
We are not,
No,
we are
no.
not allowed, we don't have no
We are
presence
not allowed
presence
to.
in there.
But
Josh
we need to know
Markey,
what happened.
Josh Markey tried to shove his way into a couple of them in Bend when he was the prosecutor over there, and he got the heave-ho. And because there's no statutory authority for the DA appearing in any respect. It's just,
We need to know they happened, though. We need to know that you have provided testimony under oath.
because
Yeah.
your testimony, your statement, is, we got to get that DMV tape and know what it says, because the defense attorney's got to have it, and we want to have it too, so.
And I can't tell you how many times I've had Bunny call me and say, well, at the DMV hearing, your officer did this. It'd be nice to know what happened at a DMV hearing. Yes, Gregory.
What they have all the details, I've never done that. I always just, you guys got a copy of
We don't.
If they had to provide what was there.
Oh, in theory.
Nope. In theory, yes.
Theory, but there's, discovery is just a completely,
One-sided.
yeah, it's defense really, there's no teeth in it for them. They can't really exclude evidence or that sort of thing, because you're eventually going to get post-conviction relief because inadequate assistance of counsel. So damn near always, when they just don't provide something, you get 15 minutes, half an hour out in the hallway to go listen to it, to do whatever. But that's the only remedy we really have.
And I'll tell you, I think some of those DMV hearings resolve our cases, but we need to know that they existed and what happened. And yes.
So, and that brings up another thing. I know we got into this a couple years ago, and I just read something recently regarding discovery on DMV hearings. Shouldn't discovery still be going through the DA's office instead of we having to provide them?
Yeah.
Yes. so give it to us and we will discover it to them, but we need to get
We
it.
send a report, we send them all our discovery.
Yes.
They request discovery from us.
Oh, you're saying before we file charges and stuff like that?
On the DMV hearing.
Yeah, they should be contacted. So a lot of times I've seen Sunil Raju and I've seen Richard Bonney both send something to, specifically, they seem to like to do a C-site where they'll send a request for all the reports and the stuff. But you guys have already sent it to us. By then it's in our custody, and so they should be requesting it from us. You can direct them to talk to us.
That's the guy who's always on the Art Larson show. He's the DUII guy out of college.
Suspenders. Kingston. And
John Henry Hansen,
I
yeah.
had him on one, and he requested the items from us, and I checked.
They almost always do.
But I was told from the DA's office to get it from, so
Yeah, we almost always tell you to, because they do have a right to it.
I would rather than with the DA's office.
Here's the thing.
Yes.
Can I comment on that?
Yes.
So, I'm talking about DMV hearings only,
Yes.
specifically, Rich. If the defense attorney is asking for discovery of anything about your case, all you have to do is tell them to contact DMV, because your agency, you are not who they're going after in the DMV hearing.
Yeah, it is. They're fighting the DMV.
DMV is
The administrator, yeah.
the
I've had a DMV lawyer wants to tell me you gotta provide that stuff.
So DMV has to give it, but you don't have to provide it. Does that make sense? So you have to.
Unless they land a subpoena on you, that, we get
So-
complaints about.
So
grand
either
jury-
direct them to the DMV or direct them to our office. I think either way, they're going to get the stuff from us.
Even there's subpoena, because they send the subpoenas to the DMV.
I
Just
don't know.
contact us, we'll try to work that out for you, because you can't ignore a DMV subpoena, just like you can't ignore anybody else's subpoena. But we do definitely want to keep track of all that.
Remember a year on that I had a DMV hearing with Steve Roman, both years with the
Yeah.
business in the case. I argued until Roman blew a gasket, that I wasn't going to get anything, that it is a criminal matter, this is civil, that if he wanted discovery, he needs to go to the DA's office. So he calls and blows Bo up, and then I think it was you, and later you sent a memo that if it is ducis tecum, type subpoena, then it is okay to release any and all.
Yeah.
Because most of the time, we don't
Justice
have.
Tecum is for the records, yeah.
The DMV hearing, as you know, has to be within 30 days. The result has to be within 30 days of the arrest. So we don't usually have the stuff yet to be able to give it to the defense on those, for DMV hearings themselves. And so generally, you guys have to satisfy the subpoena through your agency, because we don't have the discovery yet. Once we get the discovery, then we'll be happy to do it.
Yeah, so if you've already sent it to our office, then we have the records and we can discover it. If we don't have the records, we can't discover it. I think it's
If you
basically.
get one of those DMV subpoenas, ducis tecum, just give us a call, and we'll help you walk through it. But we probably don't have the information ourselves.
Since that time of day, per that letter you sent out monthly, at that time, I was always, only if I get a ducis tecum subpoena, only then will I apply or.
Yeah, right.
I mean, if they're only just sending out a regular sub, then they're not asking for records, so. Aducis tecum says that they're asking for records. Moving on to trial prep, so one of the things that in any case, especially DUIs, but in any case, please review all your video and your reports and any video that was taken at the jail before you talk to us, and before the situation. Sometimes we'll send you modified videos where we've cut out stuff that's not allowed, just to make sure that we can have you testify that's a fair and accurate copy. But review your videos. It helps a lot, so that, especially older cases. Also, most of us will check with you, or sometimes you're going to have to call us, but we will kind of talk it over with you, see if you have any questions. We want you to be prepared for trial if you're uncomfortable with the case. And then specific to DUIs, as Ron specifically told already, know your FSTs. Know how to perform them accurately. If there's a reason you can't do it, you can have an answer to that, but you need to be able to demonstrate an FST just like you would with the defendant. So try it often, do it while you're drunk, just, try it.
If you need practice, find me about 9 o'clock tonight. I'll be more than welcome to volunteer for you.
It's Friday night.
You're gonna fit right in in Clatsop County.
He does. So,
I got a couple of questions in general. Do they still play the game of just rolling down their window when they first get stopped,
Yes.
an inch to put the driver's license out and then refuse to get out of the car? That used to be the big thing that DUI attorneys would advocate. them
ones
to
who have
do.
previous DUIs, yes. So when you're reviewing your videos and your reports, please pay attention to the stuff, once again, that we need you to have in the report, which is the stuff that proves the case. Pay attention to stuff like what they told you about how many drinks they had, or very specific things like how many pills they took, or other things like that. The very specifics that help to prove a case. Please pay attention to those as you're reviewing. In larger, bigger cases, make sure you know what happened in your case, especially the older cases. All of this is, a lot of it is us talking to you, but also you need to be able to review a lot of this on your own in order to know those cases. Because we know you do a bunch of cases every day. We know that you are overwhelmed by cases. So reviewing, the purpose of body cam and reports is not just for us, it's also for you to review and know what happened at the time of the incident.
And one thing on trial prep too, at least for me, I want to lean on you guys too, because you have a wealth of knowledge and experience and years of it. What's worked at trials, what hasn't worked at trials, like things like that. Please let me know. I'd love to tap into that resource.
Yeah, and if we're not asking you a question, or if there's something that you think we're missing, let us know. Especially me and Paul, who are newer, we're still trying to learn, so we're happy to take criticism from you. At least I am. I assume you are as well.
Oh, sorry. I think some of the best witnesses are police or experts who can look at the jury but do it naturally. So I know it's a kind of a tough thing to not seem strange when you're talking to them, but I think if you can, it really comes across really well when police can do that. And I personally, and I don't know how everybody feels, but I really like to have the investigating officer in the courtroom the whole time, either sitting next to me or somehow it was objected to by the defense in the courtroom, because just like Paul said, you guys are the expert on that case. I wasn't there, so having someone who can also listen to everything that's being said and so I really appreciate that when you all are willing to do that. And I don't know how everybody else in my office feels, but I think it's really helpful. And it's more interesting to frankly for you than outside. So.
And on the topic of if you are sitting outside or even if you're sitting in the courtroom, watch the defendant, especially on DUI cases, controlled substance DUI specifically. Watch them, see if they're acting differently than they were when you dealt with them on that date, so that we can ask you about that. So if you're sitting out there and you see the defendant and he's walking straight and perfectly stationary, but during the time they were like this, make sure you're documenting that yourself in your mind while a trial is happening. So that's not trial prep, that's kind of trial happening, but that's still something that is extra helpful. All right, questions for us? Hoover.
More of making sure we're on the same page, not speaking for OSP, but I think all this needs justice. You just mentioned sending your stuff over to us.
Yes.
Is everyone clear about how that process works? Because basically, deputy arrests DUI, and within hopefully a couple days, the report is done, sent to me, approved, sent to our support staff, or our evidence tech, and then sent to you. We're not sending it.
Oh, I know you guys, okay.
You guys have to request all of those, and I don't know what to do.
So, but if we request all, and this is something that can go to your guys' evidence text, but if we request all videos and reports, we need them.
But I think they should.
No.
Frankly, I think all evidence and reports should just come because
I do too.
we have to have all evidence and reports.
Yeah.
We have to discover it. So we shouldn't have to ask every time. I'm not kidding you. This has like been a lifelong.
Yeah, this has been a,
I've always been asking for 911 calls. Well, we should always get the 911 call. And sometimes if we don't get it, it's gone after 6 months and on big cases. So that's just. how I
So-
feel.
so-
We need to have the evidence. We have to discover it.
I'm talking about the evidence that we have.
Yeah.
yes.
Right then and there, all we can say is send basically the report and evidence to the DA's office. But we're not, we as court cops are not in charge of that. I'm not going to.
I understand that you guys are not in charge of that. I get that that part is,
Yeah.
yes.
Yeah, because
Yes.
we're having to special request them sometimes multiple times, depending on which agency,
Correct.
and there's no reason to request it at all. They should just be sending it over.
And I will also clarify, there have been times where we have gotten almost to trial date and learned that there is body cam evidence that we never got, even despite requesting body cam. So that is officers not necessarily giving their body cam to their evidence tech. So please make sure you are uploading everything that you have documented.
A robbery with a knife, and certain officers no longer with Seaside, said no, I never sent it into the lab, it never got tested. And then day of trial, he told me, oh yeah, it got sent in and it tested and DNA came back with our victim. So I had to tell the judge that, and she made a lot of derogatory statements about Seaside. It was just a nasty, nasty situation, and we should have, I mean, he had the charge of that knife. It was just a mess.
And then,
Ended up being not guilty, but.
and I recognize that you guys aren't responsible for sending the reports directly to us, but you are responsible for getting the reports to your supervisors, and your supervisors sending them to us. There are a lot of DUIs that we are getting a day or two after the citation date.
I'm not speaking as far as the death.
Yeah.
Maybe more of, higher up in that, how are we gonna?
Maybe we can talk.
But stuff needs to get to us as soon as possible.
Just some clarification, because I know a lot of us are using the watch guard system, and, it's a pain in the butt when we're doing like 6 discs and 1 copy per PA, so it became a lot simpler when we could file share. What is your guys' limitation on your email for file size? Because we were running into.
You'd have to ask the girls.
Have Laura call one of our
Yeah,
people. 'cause we don't
exactly.
know.
Have your evidence tech call our trial assistants, I think is the best way to put it. We don't know that. Much like you guys don't know how the evidence gets sent to us, we don't know how evidence gets to us.
We want to do trial prep early, though, just like we
Yeah.
do in felony cases, because if we don't have something that we should have, at least we get it out a day or two early, at least it's not as likely to get suppressed.
I'm still always going to email you and ask you to review your videos because I'm neurotic like that, but please do it without me having to ask you. It's just easier.
Yeah.
Any other questions before we adjourn?
Okay, let's move on. Thank you.